classes was not introduced because of the time taken in identifying the communities which would be classified to be within the ambit of other backward classes. Again, way back in the year 89, 90s, Government of India introduced the reservation in favor of other backward classes. And in that process, the original notification tried to take away the available 3% reservation in favor of persons with disabilities in the lower jobs, which is Group C and D jobs as popularly known in India, clerical and PM jobs. There has been 3% reservation right from 1977 through executive orders for persons with disabilities. But this notification sought to take away this 3% for persons with disabilities and sought to merge it within the caste-based reservation. Meaning thereby that on the ground of disability you will have no reservation, but if you in any case fall in the reserved caste, you will have reservation by virtue of your caste. That matter was taken up by other groups, the general category people who were not covered within the reservation category, before the Constitution Bench of the Supreme Court, challenging that notification. We also intervened in that. And Supreme Court not only at the time of first hearing made it clear to the Additional Solicitor General on our intervention that any attempt to subvert or to eliminate the existing reservation in favor of persons with disabilities will not be accepted, but also warned that government should decide if they are insisting on this, we may quash the notification on this very ground alone. And that warning ultimately resulted into a consent statement by the then Additional Solicitor General that we are not disturbing the existing reservation in favor of persons with disabilities, and therefore this undertaking and consent was recorded in that historic journal. That's how we could not only save the existing reservation which existed at that time in favor of persons with disabilities in Group C and D, but on that basis we could get reservation in Group A and B also ultimately in the disability legislation. I would very quickly run through only issues which we have raised and successfully faced in other public interest litigation. We have raised the issue of, and I will not deal with that at length, the non-implementation of 3% reservation not only at the central government level but at various state government levels, and successfully decisions have come from various high courts where the governments have been asked to fill up the backlog of vacancies which have accrued and piled up. But government has, the courts have also, different high courts and Supreme Court have also prevailed on the respective governments, including central government, not to go ahead with any kind of recruitment unless you complete the backlog. Recent one is a decision of Allahabad High Court, Lucknow bench of Allahabad High Court, with respect to non-fulfillment of the backlog of vacancies in UP government. We also have taken various issues regarding reservation in promotion, and one of those issues, one of those petitions, we have succeeded in Punjab and Punjab and Haryana High Court, which is under challenge now by the respective governments before Honorable Supreme Court of India. We have also taken up the issues relating to education. For instance, in the existing law, there is a provision which says that appropriate government shall ensure children with disabilities up to the age of 18 years free and compulsory education in an appropriate, accessible environment. Delhi government, in one of its schools, notified that the children having a certain, the parents of the children who have income more than a prescribed limit will have to pay fees. We challenged that, and High Court quashed that rule, saying that you cannot charge, you cannot link it with the income. This is a statutory right given by the Act, and therefore no fees can be charged. In the housing sector, there is a provision in the existing Act that the appropriate government shall give preferential allotment of land at concessional rates to persons with disabilities or their NGOs for the purposes of housing, commerce, trade, business, and so on and so forth. This was not being done. We challenged it before the Allahabad High Court, and Allahabad High Court passed a direction that you will have to give preferential allotment at concessional rates, and I am happy to announce that now it has been translated not only within UP but in many states. This policy has been translated into reality, and the directions have been, and similar directions have been followed by other high courts also. Now, I would say that the issues which we have come across and where we have sought judicial intervention range from the issues of individual discrimination on the ground of disability, which of course cannot be a part of public interest litigation, to the discrimination on the ground of disability at large, which definitely have been a part of public interest litigation. Our judiciary has been very sensitive and very proactive. It has, as a result of these public interest litigations and the case laws developed around it, I can say with authority that this is the most beneficial tool which we have seen in the form of its product or outcome, where disability legislation and policies and even in pre-disability legislation scenario, on the basis of constitutional provisions, fundamental rights, the judiciary has evolved a very positive case law which has put the administrators on their toes and has consistently been attacking at the root of discrimination, and this probably would be a very beneficial tool for you people, the advocate friends from different countries present here, to try out and help your brothers and sisters in your country who are persons with disabilities. Thank you very much.